Facility Review Board, and we're here in docket number 16-1235-09 in the matter of Rocky Mountain Power's petition for review to the Utah Utility Facility Review Board. And we're here today on Wasatch County's motion to stay the order of June 3rd, 2016. So why don't we start with appearances. So we'll start with Wasatch County.
Tyler Burke for Wasatch County.
And for Rocky Mountain Power.
Matt Moskett and Heidi Gordon for Rocky Mountain Power.
Okay, thank you. We received the motion from Wasatch County, and we received a response from Rocky Mountain Power. I'm assuming there's nothing else that's been filed on this motion. Is that correct?
That's correct. With the deadline being yesterday at 12, there wasn't going to be any type of time to file or apply, and so we figured, or Wasatch County figured, we're just doing oral arguments here.
Okay. Well, why don't we start with you then, Mr. Berg, and if you'd like to take a few minutes and just verbally address your motion, and then we'll go to Mr. Moskett and Ms. Gordon. Thank you.
Okay. As we look at this in the motion, which I understand was very brief, the reason for that is simply because there are two code sections that we could look at to decide what, for the board to decide whether or not they could stay their order. That first code section is 54-14-307. Subsection 1, of course, says that simply asking for a review of a judicial review does not stay or suspend the effectiveness of a written decision by the board. And then subsection 2 addresses any party seeking to stay the effectiveness of a decision needs to seek that stay under code section 63G-4-405. And then as we go to that code section, under subsection 1, it states, unless precluded by another statute, the agency may grant a stay of its order or other temporary remedy during the pendency of judicial review according to the agency's rules. Well, as was pointed out in Rocky Mountain Power's reply brief, or opposition to the motion, the board doesn't have any set of rules that's saying when they will or will not stay in order. That puts the county in a difficult situation because as we were looking at this, well, what evidence is it that we need to bring before the board to say we need this action or the order stayed? As we look more into the same section 405, even starting as subsection 2 and down, doesn't really apply to the board anymore. At that point, it starts talking about what the Court of Appeals or the Supreme Court, whoever the review is by, would do if the board decided not to issue a stay. And so we're kind of left with really a little bit of, I guess legal floundering isn't the right word, but kind of wondering exactly what the board would require for a stay. Of course, at this point, the statutes require Wasatch County to issue the conditional use permit within 60 days of June 3rd. And so the county has already appealed to the Court of Appeals. The docketing statement was filed yesterday as well. We're trying to move this forward as quickly as possible. There's no way that a meaningful review can happen within that 60-day time period. And so what are we looking at? If the Court of Appeals hears the case, of course that's going to take some time. We'll have probably 30 days to get our brief in. Rocky Mountain Power will have time to reply, or in opposition will have time to reply. We're probably looking sometime late fall before we would even have oral arguments on it. And then we're waiting for the decision to come from the Court of Appeals at that point. If the order is not stayed, then the conditional use permit's issued and construction could begin. And then if the Court of Appeals were to say, wait, you didn't quite get it right, they could send it back to the board saying, hey, this is our interpretation of the code, and this is what we want you to rule on. And it could change things. It could cause problems and even additional delays and additional expenses for Rocky Mountain Power if they've already started to put the utility in the easement, if they've started to upgrade that 138 kV line, then all of a sudden they could incur additional expenses in trying to move it. Now, we can't say for sure that that's going to happen, but the requirements that are listed in 405, specifically in subsection 4, that's not what is before the board in deciding whether or not they should stay their order. That's what would be with the Court of Appeals deciding whether or not to overturn a decision not to stay in order. So we're kind of in a difficult situation right here, and the county acknowledges that. And right now, and I apologize, I didn't speak to Mr. Moss ahead of time. Did you get that yesterday?
I don't mind if you pass it out.
Okay. Well, and I didn't even have this to pass out. It's just the docketing statement that was filed yesterday and sent via email to all the parties at the Court of Appeals level. And really the only issue that Wasatch County is looking at right now was the Utility Facility Review Board's interpretation of Utah Code 54-14-303 correct. We're not saying that the standard for a stay is that you have to feel that you got it wrong. We're simply saying the standard for a stay is allow the Court of Appeals to look at this. The Court of Appeals has never had any judicial review of these code sections. There's nothing in the statute that show that this has ever been looked at. That's part of the question that Wasatch County's had from the beginning, is what exactly is the statutory language of this? We're just seeking some additional advice from the Court of Appeals, so not only in this case, but also in future cases, the board would have the benefit of knowing exactly what one of the higher courts has ruled on. I will conclude at that. I'm open to any questions, whatever order you want to proceed in. If you'd like Rocky Mountain Power to present their arguments and then do questions, Wasatch County's open to however you want to proceed at this point.
Okay, I think I may have a question or two, and other board members may also. I'll go ahead and start with one. With a statute that provides, on one hand, that an order from this board to issue a CUP has a 60-day time frame, and a presumption that an appellate review takes longer than that, and statutory language also that an appeal isn't an automatic stay. That tends to lead me to the conclusion that the statutes at least point to this board at least not granting a stay for the sole purpose that the matter is being appealed, and that would be an issue for the Court of Appeals then to consider any stay request. At least as I read the statutes, that's the direction it seems to point me. Do you have any response to that?
Well, and the county's response would be as I stated, and I know I didn't have any of that additional information in my motion. Part of that was waiting to see what Rocky Mountain Power's position was on some different things as well. But there's not a lot of direction, and so we're looking at the possibility of if the Court of Appeals were to overturn or even just request some amendment or say, hey, you almost got it right, but we want to change this a little bit. Anything from the Court of Appeals could directly affect the order. And where this is the construction of a facility, a 138 kV power line, that could be a really big event. They could already have started construction on that, moving forward with that, and now suddenly the Court of Appeals is saying, hey, we have the interpretation of the statute slightly different. So that would be the reason that Wasatch County is requesting the stay, just to make sure that we've had a chance to have the appellate review, mainly of the statute and interpretation of the statute, before any type of construction starts.
Okay, thank you. That's the only question I have. Mr. Clark, do you have any questions?
I don't have a question.
Holbrook, do you have any questions? Roy? Okay, thank you. Why don't we go to either Mr. Moscott or Ms. Gordon?
Thank you. And I'll be brief. I know that the board's prepared and has read the materials we've submitted. I won't duplicate the arguments that we filed. I'll simply note in response to the oral argument that was presented, which it is essentially, hey, this is a large electric utility facility that's being built, and what happens if the Court of Appeals gives some direction, therefore we should stay it. I will just note that every single matter that comes before this board, whether it's brought by my client or otherwise involves a large utility facility. That's the only kind of construction that this board hears. So that argument about, hey, they're going to start building a large facility exists in every case this board would have jurisdiction over, which means that if the legislature thought, hey, we should make sure we've got, let's stay that, that's grounds for a stay, they certainly would not have crafted the language that is in the enabling act of this board, which says that an appeal does not stay automatically a ruling by this board, because the logic that's been presented is that every single ruling by this board would necessarily have to be stayed. The other thing that I will just touch on that's in our papers already is the absolute disbalance between public policy, where this line, which has already been delayed by this process, is at a critical juncture of need. We attached to our papers something that was already in the record from Heber Power and Light, which they pointed out, look, we need this. We need it by, when they wrote it several years ago, within 2 years. And the requested stay is of indefinite duration. We want to take it up on appeal. We don't know how long it's going to last, but we just want it held on to. And the company, out of concern for its customers, and including customers, other power companies who have filed papers, that is just absolutely something that cannot happen. That would be a disaster for the public policy, because we are already in a position of the circumstance of their reliability that is of great concern to the company's customers. And so the power company is very concerned that the delay of any time would really put in jeopardy this project and the customers that it serves. So if you have questions, I'm happy to answer them, but I agree with, I think, what I heard from the chair, that is, if this is something that the Court of Appeals wants to go through the issues and say, we find it likely that we're going to overturn this, that's something that can be raised. But at this point, whether it's jurisdictional, out of the way of public policy, the county has put forward no argument to say, here's why we think that the Court of Appeals will overturn your decision. Here's what your decision got wrong. Here's why we think that in weighing it, you're likely to conclude that this is going to be reversed on appeal. And without that, this board simply is not in a position to grant a stay. Thank you.
Clerk, do you have any questions for Mr. Watson?
No questions.
Ms. Holbrook, do you?
No questions.
Mr. White?
No questions.
Okay, well, I guess we're to the point of deliberation or action on the motion.
Yeah, I guess it was an initial matter. I mean, harkening back to the initial decision of the board, at least from my perspective, it was based upon the need and the timing that was tied to reliability. I still stand by that. I still haven't heard any argument that otherwise it refutes the testimony provided by the experts with respect to the need and the project schedule, et cetera, and the potential impacts to the economy of the area, safety, et cetera. So I guess from my perspective, at least, I'm not really convinced, if nothing else, just because I haven't heard any argument that that's not still the case, that it really would warrant us to, I guess, for lack of a better word, second guess the board's original decision on that. So if I were to vote right now, I guess my vote would be to deny the motion for stay.
Any other discussion?
Just to provide a more complete record, I'll also include a couple of thoughts. And I want to be clear, I don't begrudge in any way the county's availing itself of its legal right to seek a review of the board's decision. I don't think the board begrudges it either. But I'm very confident that the board reached the right conclusion initially, and I don't find in the county's positions any reason to have any doubt about that, nor do I find in the county's arguments any grounds upon which I would feel a stay would be appropriate. So, and then I add to that the evidence of need and the evidence of criticality and even urgency for completing the project. That, for me, closes the door really on the issue, and so I would also vote to deny the motion for stay. And if we need a motion to act on that, I'll make it, or Chair LeVar, you can just count my vote now as being against the motion to stay or order.
Any other discussion from board members?
I'd like to. Thank you, Mr. Chairman. So I simply wanted to put my position on the record as well. Given the situation in terms of not only the primary utility, Rocky Mountain Power, but also Heber City Light and Power, and they're two entities that are separate in the same industry, that they're looking at this from a perspective of how can I close the gap and make sure that I'm serving my customers in a way that's going to be beneficial long term. My feeling also is that we made the right decision in terms of proceeding for Rocky Mountain Power, so I would say I would deny the motion as well. Thank you.
Thank you. And in the interest of developing our record and the transcript so that we have a basis for whatever ultimate order this board issues, I'll make a few comments myself too. Like Mr. Clark, I don't begrudge the motion. I recognize that a motion to this board for a stay is a prerequisite to a motion to the court for a stay. It's an exhaustion issue that has to be done. And I also recognize that both in statute and in the lack of board rules, there is a lack of the level of clarity that does exist in some places on a motion for a stay. However, I come back to a couple of issues. One, I feel like if the board granted a stay for the sole reason that an appeal takes longer than 60 days, the statute says you have to issue a CP within 60 days following the board order. To me, that would contravene that 60-day provision in statute combined with the appeal language that says it's not an automatic stay. I think granting it here would almost set precedent that it does become an automatic stay. And then getting to the public interest issues, presuming that since we don't have rules on this, one legal default could be to go to the rules that a court would consider on a stay. Just like the substantive decision that this board made on the case where you had a utility choosing between one option that could result in litigation with Promontory, one option that could result in litigation with Black Rock and Wasatch County. We made a decision that they made a reasonable decision in that case. In this case, granting a stay or not granting a stay could potentially harm residents of Black Rock and residents of Wasatch County. Granting a stay could potentially harm a pretty large group of ratepayers. So those are the reasons that lead me to the same place as my colleagues. So unless there's further discussion, does anyone want to make a motion? I'd be happy to, if someone else wants to.
Yeah, Chair LeVar, I'll move that we deny the motion for stay.
Second.
For stay of our June 3rd order, just to be complete.
Thank you. My apologies. Second.
And then could I suggest amending the motion to also have direct the Public Service Commission staff who's assisting this board to draft an order consistent with the record and the discussion in the hearing today?
Yeah, that's fine with me. I was hoping you wouldn't assign me to write it.
Yeah. Any more discussion of the motion? We have a motion that's seconded. Okay, we'll vote. Alphabetically seems to be working fine, Mr. Clark.
I vote yes on the motion.
Ms. Holbert.
Yes.
I vote yes on the motion. Mr. White?
Just to clarify, yes on the Wasatch County's motion, or,
The motion to deny the motion.
so it's a yes, so the motion is to, yeah, okay, yes. I understand that, sorry. I was thinking of Mr. Burke's motion, but now I,
Voting yes on Mr. Clark's motion.
yes.
Okay, well, it's 4-0. Wasatch County's motion to stay order of June 3rd, 2016 is denied. A written order will issue following this decision. And I don't believe there's any other business before today, Mr. Burke.
And this is just kind of a technicality, in looking at 63D-4-405 in subsection 3. The second line says the agency's order of denial shall be mailed to all parties and shall specify the reasons why, state that other temporary remedy was not granted. It seems strange, but I know whenever I get everything from the board, it's via email, and that works great. But the statute says you have to mail it, so Wasatch County would just request that a copy be mailed as well, just so we could be following what the statute says we have to do.
Thank you for that clarification. Anything else from the board?
I don't know if this is a motion or I'm asking for a clarification. I'm, just because we're now, a couple of weeks away from, when this board ordered the county to issue a CUP, and if we have the county, which I assume is contemplating further action, I'm slightly nervous on behalf of my client that August 2nd rolls around, there is no order from this board or the court staying anything, and yet the county has not actually issued the conditional use permit into, what limbo it finds itself in. And I'm just wondering if this board finds it's within its purview to, to include in its order anything along, if it has not received a stay from the Court of Appeals and yet still fails to meet and issue the CUP, is the power company allowed to proceed with construction of the line? I suppose is the question I'm asking.
And to clarify, I've spoken with our county manager yesterday on this exact issue, letting him know that if it was not stayed today, my legal opinion was that the county would be obligated to issue the CUP within the 60-day time frame, even if the decision is made at a later date to go to the board or the Court of Appeals on the issue of the stay. The CUP would be issued within the 60 days. That's my understanding right now. So, and I'd have no problem putting that on the record. I think if we were to go to the Court of Appeals, we could of course request that the stay happen at that point. If that happens, that will happen as quickly as possible. So.
I'm going to make a motion for the sake of simplicity, and I'll just say that, in my opinion, lack of action by this board means there's no stay granted. That's the way I would view things. But in the sake of clarity, I'm going to make a motion that the board issue quickly a notice of bench ruling, which would be a very short notice, just giving written notice that that was the decision of the board, to be followed by an opinion that lays out the findings and conclusions that are the basis for the order. So that's my motion. If anyone wants to discuss it or consider seconding it. And again, I'm not sure it's necessary, but just for the sake of clarification and redundancy, I'll second it. Any discussion? Clark?
I am in favor of the motion.
Ms. Holbrook?
Yes.
I'll vote yes. Mr. White?
Yes.
Thank you. Any other business for the board today?
I just want to say I appreciate Mr. Burke's clarification of the county's position. Makes our path forward more clear. So thank you.
Thank you.
Nothing further from Wasatch County.
Anything further from Rockland Power?
Thank you.
Okay. Thank you. We're adjourned.